republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, tonight is our 11th meeting, or hearing I should say, for appeal number 2023-01. Chad, our solicitor, I believe, Mr. DeFelice, you had some things you wanted to iterate to the people.
We can do it after summation. Adrian, refresh my memory. Did you make a closing argument?
None of it's did.
None of you did. You all reserved. Okay. All right. You want to go first, Mark?
Sure. So I have handed out to each member of the board, to Chad, counsel, our proposed findings of fact and conclusions of law. And then I went through it before I copied it, and I highlighted certain sections so I could just point out to you what I think are the important points. You've listened to fact after fact after fact for all this time. The first thing that is, I think, really important is that we understand what a special exception is. And I'm going to find where I highlighted that in this in 1 second. So if you go to page 13 in my document, the highlighted portion, and even starting above it in paragraph 3, and these are quotes virtually from the cases. This is not something that I crafted. This statement has been made in many, many cases. A special exception is not an exception to the zoning hearing, to the zoning ordinance, but rather it is a use which an applicant is entitled to unless objectors demonstrate, according to a standard set forth in the ordinance, that there's something horribly wrong with it. And if you go to paragraph 4, the existence of a special exception provision in a zoning ordinance indicates a legislative acceptance that the use is consistent with the municipality's zoning plan and is a use which is presumptively consistent with the public health, safety, and welfare. Now, I have seen quickly in looking at what Mr. Blasey gave me and what Adrian gave me, that all of a sudden we now have the township and Mr. Blasey saying, oh no, you don't belong here. You're not entitled to a special exception. In fact, what they're saying is, with this use, we're not even permitted to be here to try and qualify or demonstrate to you that we meet the requirements for a special exception. Well, with all due respect, that horse left the barn almost 2 years ago. Included in the record are 2 determinations by the zoning officer where she specifically determined that this use, a drip irrigation field to dispose of treated effluent to be run by or owned by a municipal authority, qualifies for a special exception. The zoning officer is the officer or official or agent of the township who is specifically appointed pursuant to the municipality's planning code And the municipality's planning code says that the zoning officer shall administer the zoning ordinance, which means making decisions like the zoning officer here made. The zoning officer, as an official appointed by the township, can't be second guessed 2 years later by the Board of Supervisors. So what I am saying is that the issue of whether or not this drip irrigation facility is entitled to a special exception if we satisfy the criteria is an issue that was long ago decided. And we heard no testimony, we heard no objection. Now at 11:59, the township and the objectors are going to seek to overturn that decision. So that's the first part of our obligation. Our obligation is to demonstrate, number one, that the use that we want to make, the drip irrigation field, is a use included in the ordinance as a special exception. And as I say, for all these months and months and months, I thought that issue was over. The second part of the legal part of this is, if you go to paragraph 6 on the top on page 14, in order to demonstrate its entitlement to a special exception, RPL has the burden of proving that the disposal field complies with and these are the important words, very important words, applicable objective requirements of the ordinance. When you go through the special exception provisions in the ordinance, section 7 or paragraph 7 really spells it out. The applicable ordinance criteria at the special exception stage of development requires that the disposal field provide adequate off-street parking, adequate landscaping, and screening to protect the adjacent areas. We have demonstrated that. And in paragraph 9, I think we set forth the corollary rule. At the special exception stage of a development, or at the conditional use stage of an overall development, that process only relates to the use of the land and does not involve specific engineering, design aspects of the proposed development. So I believe that from a purely legal point of view, I could stop right here. The use is permitted as a special exception determined by the zoning officer. The applicable criteria in this case are very minimal, and we have satisfied those criteria. Now, we felt, my clients and I felt, that with all of the controversy with regard to this development and the sewage treatment plant, that we would give this board and the residents a very detailed presentation of exactly what we propose to do. And I've sort of synthesized what we've said, starting over on page 10. I'm sorry, let me go back further. On page 7. And this is, and I'm not going to dwell on this for very long. This is just to remind the board of the length to which we have gone to try and answer questions that only should come up later in the process, just so you could get a comfort level that what we are proposing is science-based. I'm not going to read everything here, I'm just going to walk down it. We presented Fred Ebert. Fred Ebert is, in my opinion, the most knowledgeable sewer engineer with regard to the disposal of treated effluent with land application, whether that be spray irrigation or drip irrigation. There's an enormous amount of experience. I've been honored to have worked with him through the last 20 years as this science has developed and evolved. He was accepted as an engineer. He went into excruciating detail for you, explaining how the sewage will be collected from each building, how each building's sewage will be collected and pumped from the building, and it's being pumped so that it can be stopped and it can be monitored for what type of sewage it is. It then gets pumped down to the pump station that will be down near River Road, where it's again monitored for what's in it. It then gets pumped up the hill, up towards Potomac, to a sewer treatment plant that is the state of the art. It's called tertiary treatment. It doesn't create drinking water, but it creates treated effluent that complies with the requirements of the Safe Drinking, the Drinking Water Act. And again, at that location, it's tested, monitored, to make sure that the only thing that goes into that sequential batch reactor is sewage that can be treated biologically. After that's done, it gets conveyed over to the drip irrigation fields. My second witness was somebody with equal experience. I think I've known Joe Valentine for 35 years, all over Bucks County, all over Lehigh Valley. Joe Valentine is a sewer expert. He's a soil scientist. He's got every credential imaginable. He's the guy that you call when you want to determine whether you can use your property or a property for some type of on-site system. That on-site system could be a biological, natural treatment. It could be for a single-family house, or it could be, as we're talking about here. You heard Joe's testimony. He tested all over this property, whatever we have, 89 acres, and by the way, so there's no question, the DEP people were out there with him when he did the testing. We had Mr. Cribbs talk about all these phantom other pits that we didn't report on. Well, if you recall Joe's testimony or Fred's testimony, they did a whole series of preliminary test pits to see whether they should go farther. They did well over 100. They limited it down. They listened to what DEP told them about where to test. And they ended up with what you heard, I think 22 acres, an area where the drip fields can be located. The third witness, again, another very experienced hydrogeologist, again, somebody that, not that it's important, but I've known for years and years, and my clients have used Jeff Clark wherever we had to know the hydrology of an area where there was going to be a development, either where there's going to be infiltration of stormwater so that we can be sure that the ground's got the capacity to absorb stormwater, or in this situation. And it was very interesting to listen to Dr. Elliott tell us, and I mean that in a good sense, what kind of testing should be done. Well, it was pretty obvious to me that Dr. Elliott had not read Jeff Clark's report, because Jeff Clark did exactly what Dr. Elliott was talking about. Dr. Elliott called it a water balance test, and Jeff called it a different name required by DEP, a mounding analysis. And what's that? The water balance and the mounding analysis is, we're going to put more water on this property. At what point is something, a mound or something else, going to say, stop, you can't put any more water here? That's what I believe Dr. Elliott was talking about. And if you recall, between Jeff and Fred, they demonstrated a capacity to absorb the treated effluent that's 2 or 3 times what's planned here. There is that safety level. So, again, that's the technical stuff. And Dr. Elliott said it, and we agree with it, that we're at the very beginning stage of the Department of Environmental Protection monitoring and permitting. So Dr. Elliott wants us to comply with all the DEP requirements we're required to get permits. So we're in agreement with that. Well, let's go beyond that. What the 3 of them testified to was that after the system is in, there is a very spelled out protocol on testing, quarterly testing. Fred went all through it. There's 5-year testing, there's each year testing, where an engineer's got to come out and certify as to how it's operating. And as Dr. Elliott told us, there's a long history in this state of treated effluent being disposed of by ground application. So there is a protocol there. It will be monitored as it's permitted and after it's installed. Now, so then what did we hear from the objectors' experts? So let me go to page 15, paragraph 13, because paragraph 13 tells us what the objector's burden of proof is. As I think you've heard, it's our obligation to do two things. Demonstrate, one, that we fit in the category for special exception. Number two, that we meet all the criteria, which are minimal here. And I've added the criteria to demonstrate to you why this system is properly designed. Then the burden shifts to the objectors. The objectors have the obligation to introduce credible, relevant, probative evidence, and here's the language, demonstrating to a high degree of probability, demonstrating to a high degree of probability that the disposal field, and here's more words, will create a greater adverse impact than that which would normally be expected from a similar use of the size and type proposed. So what does that mean? It means, going back to one of the first things I read, that if a use is permitted as a special exception, there's already been a legislative decision that presumptively that use is consistent with health, safety, and welfare. So when somebody wants to object to it, they've got a really high bar. They've got to prove to a high degree of probability that the proposed use, the disposal field, will create a greater adverse impact than that which would normally be expected from a similar use of a similar size and proposed use. So what's that all about? So a special exception is a permitted use. It allows the municipality a fail-safe to be able to say, we're going to make this as a special exception. Normally, that use is permitted. But if somebody comes in with a use that's ostensibly permitted, but is so extreme in some manner, shape, or form that it creates an impediment to health, safety, or welfare that is so much greater than the normal use, well, then it can be turned down. I'm sure Chad will explain it to you, but that is one hell of a burden. So what did we hear? What did we hear from the objectors, experts? Mr. Cribbs is a recognized hydrogeologist. There are clients of mine who use Mr. Cribbs, particularly in situations involving development in karst areas. But that's not what we're here about. And Mr. Cribbs gave us a lot of speculation. While Ebert, Clark, and Joe Valentine did physical testing to determine whether or not this ground can accept the amount of treated effluent, Mr. Cribbs speculated. How did he speculate? He said, well, I'm very familiar with this type of karst condition, and this type of karst condition, this is what I heard, is so tight that it's not going to allow the water to go through. Well, I'm sorry, but that's just not credible. We proved otherwise. But that's all that he said when you boil down all of his testimony. The other thing he did was he made some allegations that I thought that were completely out of line. Took our drawings, blew it up, took a drawing that showed the 125 or so places where we did initial testing to to hone in on the right place, and he said, there's something wrong here, they're hiding something, we should know what that is before we go forward. Well, that's not based on science. The science was Joe Valentine and Jeff Clark. I don't think that Mr. Cribbs said anything beyond that. The second witness was Mr. Sterling. I'm going to be kind, but that's one of the worst witnesses I've ever seen. He was totally incredible. He could not answer a question directly. And if you remember my opening cross-examination to him on all series of questions, I asked him questions that were susceptible to a yes or no answer. And no matter how many times I pushed him, no matter how many times Mr. DeFelice pushed him, he used some expression that some lawyer taught him one time that said, well, I can't just answer it like that, because if I answer it yes or no, I'm going to mislead the board. That's poppycock. That's absolutely absurd. The man never answered directly. He told us that he was going to use a methodology that is paired analysis. He pulled those words out of the appraisal of real estate, and I'm going to use paired analysis. And if you recall my cross-examination, he didn't use paired analysis. Paired analysis required the comparison of two sites that are very, very similar and have one difference. And the idea of paired analysis is to locate, determine the value plus or minus for that difference. He took that concept and took data from the entire Lehigh Valley and said this is a measure of what houses are selling for, and then he picked and chose the particular sales that he wanted to use to show that there were a 9% drop. Well, I think I demonstrated with the materials that my people put together that he flat out committed a fraud on this board by hiding a whole series of sales that he knew about. And what did he say when he was called on it? I think Chad asked him. He said, well, I didn't use those examples because it proved what Mr. Kaplan was looking for. Mr. Sterling is not credible. Dr. Elliott is exactly the opposite. Dr. Elliott is an expert in the disposal of treated effluent or stormwater on lawns, grass, etc. But his expertise was not in drip irrigation. His expertise was in, or is in, spray irrigation. But put that aside. What did Dr. Elliott say? You have his report. Right out of the box, the second or third paragraph said, if properly designed and implemented and watched, the disposal of treated effluent as a land application is a safe application for health, safety, and welfare. In a way, just that statement undercuts any argument that the objectors or the township can make that there is something wrong with this system. So, I'll try not to hold you up any longer. This is the first step in a multi-pronged application process. We need to get the special exception. We will then go through the permitting. We have already submitted to the township our planning module that has been reviewed by the township engineer on a number of occasions, and we are waiting for the Board of Supervisors to approve it so they can move on to DEP. There will be construction drawings. There is an agreement, a signed agreement between my client and the municipal authority for the municipal authority's engineer to review every part of our plans and our applications. And they have to be satisfactory to him within normal engineering bounds. We have to complete the land development process, and ultimately we have to build the system, all of which has to be permitted and inspected. And again, we are at the first step, and our obligation is very simple. Prove that it's a permitted use and demonstrate that we satisfy the criteria and defend against allegations to the contrary. So I ask that you approve our application. Thank you.
That were offered but not necessarily marked, so I'd like to, that were offered and marked but not necessarily admitted, so I,
Let's do that after. Should we do that after?
oh, all right,
Make your argument and then we'll do that after the thing like the.
okay. Then just, and I've given paper copies of the revised document that I added 2 words to before. So should I give one to the reporter and you one, Chad? Because I think members of the board already have it electronically, and I can quickly tell you what 2 words I changed when I realized I didn't see them straight the first time. So I've given them to my colleagues here. Do any of you want these extras?
I'll take it.
Are we making the written submissions part of the record as well?
Yeah,
Okay.
I assume that.
I'm sorry, what did you say?
Are we making the written submissions part of the record as well? I assume.
Oh, sure.
I don't think they have to be.
No, they're not really part of
Yeah,
it.
there are.
Well, I have tried in what I've generated and submitted to the board and to my colleagues, go through this systematically and make references to the transcripts all along the way. So there'll be an opportunity for fact check me, if you will, and see if what I'm saying conforms to what the transcript says, and trying to make a coherent story out of some things that were frankly at times confusing. We'll get to that. And I guess the first thing, right, okay. Now, is that better? I guess that's better, sorry. So if you look at, and I can't give you the page number because I had to enlarge the print so I can read it, because I can't read right now the small print. So, but if you look at essentially your first page, there's a general overview and it says the intervener's observations fall into one of 4 categories. Let me just briefly cite those and then we'll start talking about each one individually. I don't think, frankly, the applicant has met his prima facie burden of establishing that he's entitled to this, and we'll go into that in considerable details. And among that, he hasn't addressed, I think, requirements in section 4.202 regarding the potential environmental impact of this activity. And I think the board has independent responsibilities from the DEP. So whatever the DEP may say, it can say, and there are processes for challenging and appealing that and reviewing that, but you have some duties independent of that, which have to do with the risk to the community and whether this activity is appropriate to the community. And those aren't considerations relevant to the DEP. So considerations that are within your authority you need to make, and we'll get to those. Closely related to number 1 is I don't think this use, this activity, and I'll go into detail, is allowed at all under this ordinance. And respectfully, I think the township and its engineer, who historically have been very thoughtful and careful about this, missed an opportunity to say, no, this doesn't belong here. And I'll tell you why it doesn't when we get to that as well. The third category has to do with real issues of harm. And while the testimony of Mr. Sterling was often confusing, I'm going to try to straighten it out and show you how there was a clear line of thought and there's a clear harm existing now in the market to homes adjacent to that drip irrigation field. And that will continue indefinitely. And we'll go through that. And then the last category, again, kind of goes back to the risk that is associated with a potential error. And we'll talk about that. Now, the DEP, I think the applicant has made considerable efforts to design and a system that has safeguards and backstops and this and that in it. But at the end of the day, we're putting approximately 400 new homes, the equivalent of about 400 homes on 23 acres. That's about 18, 19 homes per acre. And all of that waste is right up above everybody's water supply around them. Now that's a risk issue, and if there's an error, who bears that consequence of that error? It's the homeowners, not the developer, and not the source. So we'll talk about that, and I think that's your duty to assess whether this risk is appropriate for that neighborhood, particularly when there's another place for it, where the township supervisors decided would be appropriate for this type of use. So having said that, let's talk a little bit about the prima facie case. What is needed to be shown to be entitled to the special exception? Arguably, that I would think the very first thing you have to show is that your activity complies with the language of the special exception essential services use, and it doesn't. And I think, in fact, when you look at their application, they will agree with me, because the supplement to their application, and these are citations all in the report, it's hard. This is the application of December 2nd, 2022 to the township. And then when you go to the addendum prepared by Mr. Kaplan's office and submitted on behalf of the applicant, look starting at roughly paragraph 20 of that application about what they say they're proposing to do. Number 20, they say the regulation which forms the basis for comment 3 of the review letter is inapplicable to the off-field disposal site. Presumably, that's the site we're now talking about. Then 21, we're talking about the off-field disposal site located on the Angle property. The Angle property, blah, blah, blah. Because the off-field disposal site is not located within the industrial park, nor within the I-2 or I-3 districts, Ordinance 2020-20 is wholly inapplicable to the off-site disposal field. There is no similar setback requirement applicable to essential services in the R1 district, nor any lawful basis to apply an I-2 district regulation to the permitted use. So they're trying to distinguish here the requirement in the text amendment, which said there would be a 500-foot setback from sewage facilities from the disposal field. And they go on to say, look at 23, and then it follows. All sanitary sewage systems are necessarily comprised of several components, including a collection system, a treatment facility, and a disposal system, stream discharge, spray irrigation, or drip irrigation for that disposal system. Indeed, the definition of essential services differentiates between subsurface components, sewers, and above-ground facilities, pump stations, treatment plants, and similar facilities. Although making numerous references to these various components of a sanitary sewer system, Ordinance 2020-20 inartfully prescribes a 500-foot setback between sewage facilities and any house, but fails to clearly define facilities. They go on. I'll jump over 24, but is intended to provide a mandatory setback between a sewage treatment facility and any existing residence, not to require a setback between any aspect of a sewage system and nearby residents. The intent was to mandate a minimum separation between a residence and a component of the sewage system that has the potential to cause impact to the residents of the home, i.e. a treatment facility. The other components of the sewage system, including conveyance and disposal of fully treated effluent, have little to no visual or other impact on a residence, and therefore a mandatory setback would be unwarranted. 25. This intent is consistent with the definition of essential services, which makes a distinction between subsurface components of these services, which are permitted without reservation, and above-ground facilities, which are separately and independently addressed. Now we can keep going there, but look, go to 26 of their application. There's addendum. Moreover, the language of 2020-20 makes reasonably clear that facility refers to the wastewater treatment plant. Immediately following the stated setback addresses sludge generated by any sewage facility. Sludge is only generated by a treatment plant. Off-site disposal consists of subsurface drip irrigation of fully treated effluent. There is no sludge associated with this aspect of the sewage system. Thus, the words sewage facility are clearly used interchangeably with treatment facility and are not intended to reference all components of a sewage system. Accordingly, the 500-foot separation between a sewage facility and any house and does not apply to either the on-site disposal field or the off-site field. Now, when we then turn to the definition of essential services, which is found is a definitional section, 2.1777, it says, the erection, construction, alteration, or maintenance by public utilities or municipal or other governmental agencies we'll get to this in a moment, particularly since the township has directed the currently existing, I'm not sure if it's still currently existing, the municipal authority it created, I think, in 2023 to dissolve itself. There may be no such one, but of underground or overhead gas, electrical communication systems. And just think about these things as you visualize them. Do any of them have a disposal component associated with them? And the answer is, I think you'll find none of them contemplate the disposal of anything. They contemplate the utilization of land as a position for the facility, support for the facility, but none of those facilities are disposing of anything on that ground. So they include antenna towers, commercial communication towers, wireless communications, water transmission or distribution systems, including poles, wires, mains, drains, sewers, pipes, conduits, cables, fire alarm boxes, police call boxes, traffic signals, hydrants, and other similar equipment and accessories in connection with and reasonably necessary for the furnishing of adequate service by such public utilities or municipal or other governmental agencies or for the public health, safety, and welfare, but not including buildings except telephone booths, firehouses, pump stations, treatment plants, and similar facilities which shall also be considered as essential services. None of those contemplate disposal. They're not talking, there's no word of a landfill, there's no word of a drip irrigation field. The only, again, it's in my report, the only place, and you'll see this township has been exceptionally mindful in its entire zoning ordinance to limit disposal activities. The closest thing they come to disposal in the landfill sense is a transfer station, as I recall, is allowed, and a recycling facility, I think, were for landfill purposes. None of those are disposal, processing. And then for closest you get to disposal is mulching. Vegetative waste can be mulched in where? I-3. So the only place you can even put vegetation on the ground for mulching is I-3. So I respectfully suggest that the zoning code and this portion of essential services contemplates these passive activities which, except for a break or a release or an error, have no disposal component associated with it whatsoever. And I don't think the applicant has made any showing in its prima facie case that this drip irrigation field meets the language of this ordinance. Now, while I said respectfully, I think maybe the township missed that initially, it did so in good faith because they've been very, very careful in doing all of this. But to me, that's critical. That's straight legal. Forget now the facts we'll get to in a moment about what the harm is. I don't think it's entitled to it. Period. End of discussion. And if it was missed 2 years ago or in December of 2022 when it was submitted, this board doesn't propagate error by saying, oh, well, it's too bad, we'll just overlook it. It's like a court and jurisdiction. If a court concludes it doesn't have jurisdiction, it's always proper to raise that and say, it doesn't belong here. So if you conclude this activity is not covered by this ordinance at all, and I don't think it is, they're not entitled to this as a special exception, period. And I tried to carefully go through that essentially in the first two sections of what I said were the 4 points we'll cover. And if you would take the time, and I'm sure you will, and your solicitor will, to look, I tried to organize it more carefully than perhaps I'm saying verbally. So now let's just turn then to the witnesses, because another component of what this board is responsible for is ensuring that no activity involves harm to the neighbors and is consistent with what the neighboring uses are. And remember, what we've already just talked about are basically uses supporting those neighbors. Phone lines, a water line if there were public water, sewers, fire hydrants, But a lot of it has to do with electrical lines. Those are to support that community. This drip irrigation field is not supporting the neighboring community one little bit. In fact, it's threatening it. Now, they think they've built in safeguards. I know they've tried hard to show that, but there is a risk associated with it, and that risk is real, and our experts are going to talk about it. The first risk is what was raised, and it's not a risk, it's a reality, by Mr. Sturley. Now, yes, that was difficult testimony to follow. He was trying to explain various things, and I made citations carefully to each and every statement where there was confusion as to how I think it was intended. I think I myself created confusion on one point by urging him to use the word updated when we were clarifying language. I thought for clarity, but not new data. I footnoted that so you would know that. But he is the only expert that was called on the value of real estate. The applicant didn't challenge what Mr. Sturley says, and obviously has a very unfavorable opinion, or wishes you to have a very unfavorable opinion of him, but put on no expert of their own to contradict it. And we did ask, and I don't know, I'll renew it, that applicants exhibit A 28 through 30 be stricken. And I don't know that there was ever a formal ruling on that. They're in the record now. There was testimony about it, but if they were ruled to be stricken, we can drop a lot of stuff. That was where Mr. Kaplan tried to bring in newly created documents suggesting various aspects of the multi-list that they thought were relevant, but they had no foundation, and we don't know who created them. So what did Mr. Sturley attempt to do? One, he's clearly a certified appraiser. He's got all kinds of titles and responsibilities and has had for decades in this Commonwealth in doing this work. And he said, I need to do or hear a paired sales analysis. The first area of confusion related to Mr. Sturley was, well, how's that an appraisal? Have you looked at the requirements for an environmental appraisal? And we said, no, I didn't. But it wasn't relevant. He said, just answer that yes or no. Well, why wasn't it relevant? If this firehouse, this municipal building, if you will, were to go up for sale, and somebody did a phase 1 report and found there were some old storage tanks and whatnot, and you had to actually determine if there'd been a release on this property, was there contamination on this property, to what extent did those conditions affect the value of this property? What was being raised by Mr. Kaplan would be true. You might very well need an environmental engineer to tell you what the cost of cleaning that up would be. But if you're looking instead at what the market reaction to potential conditions, they're not just actual real current releases, but potential releases are, you're looking at what the market is telling you. And Mr. Sturley said there's a process for doing that. And that section, the witness section, which leads with him and then follows up with Mr. Cribbs, which we'll do in a moment, clearly says you look to see if what the entire Upper Mount Bethel market looks like. And you even can look more broadly at the greater Lehigh Valley market. And you do that by looking at days that houses remain on the market and how their listing price relates to the final sale price. And you get a sense of whether the market's moving quickly, whether the estimates are coming of value are reflected in the actual purchase prices. And that includes all of the outliers. So it would include those that aren't performing. It's the broad market. So he then was saying what this market was and what he looked at to do that. And then was there anything that was differentiated, where there's an area different, where properties were being handled differently in terms of days on the market and pricing and value. And lo and behold, right below the drip irrigation field, he had found 4 properties And later, when we looked at what Mr. Kaplan had offered, there were 2 more that we found that were in that immediate area, where the market was saying people were scared or worried about those homes being so close to this proposal. So that's a real harm. Now, will it actually occur? Let's hope, if this board were to approve it, which we don't think it should, for the reasons I've been talking about, and everything worked fine, people might still be concerned there could be an error. There are always errors. Airplanes fail. Trucks run into bridges. Mistakes occur. So it's likely people will remain concerned, even if it seems to be working fine. And that issue is harm to the people who have bought homes there, or sell their homes there. They are exposed to that, both the risk, but also to the market depreciation. And I respectfully submit that looking at those issues aren't DEP issues. Those issues are community-based risk and the welfare of the zone where the use is being proposed. And so then he finishes that paired analysis and says, there was a lot of objections to hearsay, that he went and looked at records, looked at zoning hearing board, looked at planning commission stuff, went to the diner. That's how the market acts. Why are people here? Is there anything else occurring near Potomac Street that has got people worried at this point in time, or has had them worried for the last 2 or 3 years? No, it's this. So he clearly did a paired sales analysis, showed harm occurring now, even though the use is not yet in place, so we can't say it's causing pollution yet. It's a proposed use. It's causing harm. I say that is sufficient for this board, under the terms of your obligation to grant a special exception, to support that denial. Now let's turn to Mr. Cribbs for a minute. There are a couple things, and there's an area of, I think, almost agreement. When Mr. Valentine testified, and I made the citation in my submission to you, he basically said the soils are such that all the water is going to go through them and get right to any confining layer. There's going to be no horizontal movement in the surface soils because they're very conductible from our test pits, and all's going to be fine, and it'll go right down. Well, when it goes right down, where does it go? This is where we now have to pick up Mr. Clark. Well, Mr. Clark seemed to be saying that a lot of where that water was going would then be moving horizontally, not now through the soils, but along the first confining layer they found. Now, he concluded initially that most of that water would reach the wetlands adjacent or on the Angle Farm property, or the streams flowing across it or through it, and then eventually off it.
Doug, who is he?
Mr. Clark, you're and then, I think it was under my cross-examination, I asked him whether any, and again, there's a citation to all of this, whether any water was going to reach the water wells of the neighbors. And he said, well, some could, because there are fractures and they could penetrate to the groundwater table and move towards the homes. That's exactly what Mr. Cribbs was testifying about and saying was not just a potential, but virtually a certainty in his judgment, that a high spot like the Angle Farm was actually the source of groundwater for the lower areas around it. So again, if all is perfect and you're just putting rainwater on it, when it moves down to the aquifers and moves towards people's wells, You might pick up a few agricultural chemicals or fertilizers, and they talked about that. But the risk is if something goes wrong with a system not intended solely for sewage and organic waste, but to take industrial waste that have been deemed acceptable for this process, goes wrong, you've now got water wells that everyone is dependent on that are contaminated. And they-
Objection, there's nothing in the record that supports that statement.
If all is perfect and you're just putting rainwater on it, when it moves down to the aquifers and wells, you might pick up a few agricultural chemicals or fertilizers, and you talk about that, but the risk is, if something goes wrong with a system not intended solely for organic waste, sewage organic waste, but to take industrial waste that has been deemed acceptable for this process goes wrong, you now have water wells that everyone is dependent on that are contaminated.
I said,
There's
if,
nothing in the record to support that.
yeah. So again, think about the use. The use is intended, it's an industrial use for a very large industrial property, putting the disposal element above and on agricultural and residential ground. So all the risk of any error is now on people who had every expectation that everything around them would be similarly agricultural or residential. I think that your duty is to give them protection against that risk, quite independent of whether they could get a DEP permit for it, and we're going to get to that in just a moment. The other thing that Mr. Cribbs was saying, because I don't think it's just it's not just the groundwater. There's a surface water issue here as well. I think you heard the Onifrax, both Michael and his wife Regina, testify about, and I think the stick I got here is just for I-9, which was the flowing stream. You could see how much under rainfall conditions, a stream through their property, the elevations and the amount of water flowing in it. They testified about the water in their backyard coming up through the soil, and you could, and how they could see it. So there's a surface water component here. So even if this water hits that confining layer and moves towards the wetlands and the streams, Mr. Cribbs said, when you more than double the flow, remember, rainfall is about 45 inches a year. They want to add 61 or 2 inches of water to that, to this 22.3, is it 22.3 or 22.9? 22.3, I think, acres drip field. You're more than doubling the water. So if they're already having wet yards and flowing streams, what will doubling that do? So there's a concern for that surface water. And if that starts to bring contaminants, we now have it flowing against properties and in the backyards, against play sets, sandboxes, and perhaps into basements and causing vapors. These are issues this board has authority to consider, and consider a risk too great for the citizens who had no expectation and no reason to think this ground would be used for disposal. And frankly, as I said first, the ordinance doesn't contemplate disposal uses there, period. Now, the second aspect of what Mr. Cribbs was saying was he thought, and this will be confirmed by what Mr. Elliott said, Dr. Elliott said, that there was a lot of missing material or data that he could not find in either the Clark report or the Valentine report. And he indicated which of the various test pits had been dug that no data was associated with in the reports. When we get to Dr. Elliott, he in his testimony said he thought the frequency of test reports was minimal, and the DEP would likely require many more. So I think, and very respectfully, and I'm very glad the township is here and represented and has been active in this, if this matter were approved by the board such that the DEP activities would proceed, somebody needs to be a true third-party observer and advocate for the community, the township, and the immediate residents to make sure that the DEP does everything, and perhaps also the DRBC, necessary to ensure the safety of every resident around it. When we get to Dr. Elliott's testimony, the key element of what he was saying was these systems, whether it be drip irrigation or spray irrigation, are intended for sanitary waste and organic waste such as food waste and maybe pharmaceutical, I'm not sure he said pharmaceutical, but it would be food processing waste and sanitary waste. They're not intended for industrial waste disposal. Now somehow, if there is an industrial waste component, he said, they would have to have the full pre-treatment spectrum applied so that anything not susceptible to the organic treatment facility that was going to process it would be removed. And you had to be assured of that. But overall, these uses are for sanitary and organic materials. This is an exception. This is an extension, quite an extension, to talk about 6.5 million square feet of industrial warehouses and manufacturing, which somehow will design a wastewater treatment system that has all the fail-safes that are needed to prevent any mistake from ever happening. You think that's happening around the Superfund sites? Do you think that's happened all around the nation where we're cleaning things up? Do you think that doesn't happen every day? There are errors and mistakes. I don't think the residents of this community deserve to have potential, because I'm not saying they're intending it or it will necessarily occur, but the potential is there, placed above their water supplies that they're all dependent upon. So then Dr. Elliott had certain recommendations, and then I think this board and your solicitor asked that we all suggest special conditions that we would think would be appropriate if you were to grant it. Now my first view is, it's a no-no. I don't think they've met their burden. If they met their burden, we've showed that there's a legal infirmity that this board should correct. Disposal activities aren't entitled to use in this area. That's in your ordinance. There's not one of those issues has a disposal component associated with it. And lastly then, we suggested a lot of special conditions that there be very active pursuing of this to do your darndest to protect people. But realize the risk is still there. And we don't think, my immediate clients, but I think the entire community doesn't think they should be bearing the risk for this project when there's a lawful place where it should go, and in our view, this one is an unlawful site for it. And then we'll do at the end maybe the whole proceeding, the exhibits that I need to mention. Let me just see if there's anything else before I turn it over. I think I'm pretty well covered it. And what I tried to do was kind of walk through the record in these discussions to not just give you a legal citation or a proposed finding of fact, but show you where it was discussed and how I came to that conclusion. So if you want to, and you clearly should, look to the record to support things, I've tried to do that for you. So thank you very much.
Okay, I will try to be brief. so we can get to your deliberations. Township's point of view on this, I'll reference, is that coming through? Okay, loud enough? Okay. Attorney Kaplan talked this morning about it's been 2 years ago that ship has sailed. One of the things that zoning hearing boards do is review the decisions of the zoning officer. Yeah, I'm on. And so there's nothing in anything that's been cited that says that that decision by the zoning officer that this is a public utility and therefore subject to special exceptions could not be reviewed by this board and could not be determined to not fall within that category. There were two decisions, and I think it's important that we talk about the two decisions that were made, because the first application was for a private sewer, private wastewater treatment plant. And the zoning officer said, no, that's not permitted unless you get a variance from this board. And variance has a different standard. I don't think Attorney Kaplan has misstated what the legal standard is for special exceptions. It's different for a variance. And that's why they're here saying this is this is a special exception. We don't believe it is. We believe that in order for it to be a public utility, it has to serve more than one private client. And that's what we're talking about here. We're talking about RPL and its tenants this is not for the broader benefit of the township residents. This is a wastewater treatment plant and drip field irrigation system that is benefiting only one particular client, one applicant. And that's why we don't feel that it falls within the definition of the public utility that would put it in that special exception category. I put this in my brief. I'll just quickly refer to it. The Public Utility Code does define what are public utilities, and one of those things is sewage collection, treatment, or disposal for the public for compensation. It's not just one part of the township, and that's what we're talking about here. When we talk about, and it's not quite the same thing, but when they talk about whether something's public or private, what comes up mostly when you do research on that is when townships take property and what they're used. And there's a case that is cited here, C.E. Dunmire Gas Company versus Pennsylvania Public Utility Commission, and it talks about whether a facility is private or public in nature does not depend on the number of people who use the service, but whether or not the service is available for all use of the members of the public who may request it. That's not what we have here. We have one particular, and quite frankly, it's an easier path for the applicant to come for a special exception. That's why they've turned this around, dressed it up as a public utility. That's why they sponsored or encouraged the formation of the municipal authority. And to clarify, the municipal authority still exists. The township has ordered it to be dissolved. But one of the reasons that they did that is because the municipal authority created just for the benefit of this particular applicant and not for the broader.
Objection. None of that's in evidence.
This is argument. Excuse me, and I don't have to
It's
put it
not
on.
in evidence.
things that aren't happening.
I'm making arguments about what occurred. I mean, that's perfectly permitted. Okay. So, in summary on that particular issue, we don't believe this is something that should be submitted as a special exception. And the evidence is, there are no sewer in this township. Everything that is being proposed here is just for the benefit of RPL and its tenants. So we're not talking about a broader public benefit. We're not talking about something that's going to be helpful to the township. A lot has been made about this will be turned over to the township and what a great thing it is, but the residents of the township then are responsible for this particular facility and what happens to it and what goes wrong with it. I won't repeat all the arguments made by Attorney Blasey, but yes, accidents happen and that is a concern. And all the safeguards in the world are not going to protect the residents that are harmed by an accident. I think you heard credibly from some of the residents who had either party status or they live in close proximity to this field. They're concerned about something happening, something that they can't anticipate right now. Accidents do occur. And that's a reasonable concern for somebody who's got health concerns. In the future, something could happen. We're relying on safeguards that are put in, but there are reasons why these safeguards sometimes fail. Some of them are human. I'm not saying that the system that's designed is one that has not been properly designed to try and catch all the particular safeguards, all the particular issues, but accidents happen, things happen. And the tenants are, their profits are going to be what are concerns them. I'm not saying that they're gonna deliberately do things, but shortcuts happen. And we have to rely upon monitoring and oversight, and things do go wrong. And so not only is it not a public utility, this is a reason why we believe that this should not be approved as a special exception. I've been shouted down, and other witnesses have been shouted down about putting this particular drip field irrigation system on something that is in the I-2 or the I-1 section. And that's admittedly not before this board. But when we're talking about the public utility aspect of this is why it's important. Because if this is a hardship before this board, because it's not a special exception, they would have to demonstrate why it would be a hardship to put it on the R1 zone versus the industrial zone that they own, and they could put it there without this process. So I'll move on from that. The referral to the Planning Commission that was done, that should have been done initially. Procedurally, it should have been done before this actual application went forth. I received a letter this afternoon from Attorney Kaplan's office saying, well, they did receive it and they chose to take no action. And I'll concede that the ordinance does not require them to take action or require them currently in its current form to make recommendations. But what we received in that letter was, we didn't have a chance to do it, we didn't come to any of the meetings, we don't know enough about it, we're not going to take a position. If the procedure had been properly followed, they would have had that opportunity because it would have gone to them. And that's for the board to refer to them, to the Planning Commission, and perhaps they would have had the opportunity then to make additional recommendations and recommendations. So we think that is another reason why this is not done in a proper manner. The health, safety, and general welfare that has been discussed. If there's a case called Moore Development, Mifflinville versus Mifflin Township, it's a Pennsylvania Commonwealth Court in 2017. And council is correct about the shifting of the burden once they've found the objective criteria of the ordinance. But it's not just health, safety, or the welfare of the community. In that case, they say, or that it would conflict with the expressions of general policy contained in the ordinance. Attorney Blasey went through this. There's nothing in the ordinance that contemplates this kind of drip irrigation system. It's not something that is consistent with it. It's not something that has been contemplated even when the text amendment was done. These are kind of things that we believe that the witnesses have credibly shown do not fit within that expression of general policy. I will also say that I found it especially convincing to me about the real estate portion of this. And I'm not talking about Mr. Sterling. You heard from at least two of the people who stood up here who own property right there and said, I would never have bought this property if I'd known this was going to happen. Because they would never anticipate it. Because what they want is to live in this township for all the reasons that all of you live here, because of the nature, because of the environment, because of the things that the peace and quiet. And so, yes, it's not evidence of an appraisal that I'm talking about. I'm talking about actual people who have testified that we would not have purchased it. that is I think something that you can take note of. And there are concerns. I mean, you have people up here with real health concerns about having this put right next to their wells. We don't know everything that's in those soils currently. We don't know whether there's PFAS. We don't know if there's heavy metals. We don't know of other contaminants which are not required to be tested by either DEP or others for this particular kind of process. But what we know from the evidence presented by the applicant is that 100,000 gallons of water is going to be put on that property every day, and I believe it was Mr. Ebert who testified to this, that will push whatever's in the soil down much more quickly, which means that will get to the aquifer, that will get to the wells more rapidly than otherwise. So something that may be in the soil now that may be harmful may not have made it all the way down to the wells for a longer period of time, but we're putting 100,000 gallons of water on top of it every day now. That's going to accelerate that process. The issue of the recusal of Mr. Manzi has been brought up. Manzi has been brought up a number of times. We believe that he has sort of indicated very verbally during this process that he's in favor of this from the beginning. He constantly cited to these properties in Florida. He has been requested to that are next to $1 million homes where they have a drip irrigation system that apparently is not similar to the one we have here, but is a drip irrigation system nonetheless. He also, there's been testimony about him selling property to the applicant here. At the very least, we think there's an appearance that he's not independent, he's not unbiased, and for those reasons, we believe he should have recused himself. Now, counsel for the board has made it clear that that's a decision that he should make, and he should make alone. We believe that he should have taken an opportunity to clear that issue from this board and should have recused himself. We believe that the application should be denied for all those reasons, all the reasons that Mr. Blasey's clients have set forth. We also have submitted in the alternative, and if this board does decide to grant the special exceptions, and again, we're not advocating for that, we're actually asking this board to deny the application. But we've listed in our brief, starting on page 12, 7 specific recommended special exception conditions that have been provided to us by the township engineer, looked at by the board of supervisors, and have been passed on to this board as recommendations. Do you want me to read them into the record, or are we just going to make it? Okay. All right. So number 1 is provide baseline well testing for the residential users within 1,000 feet of the proposed drip disposal fields on both sides of Potomac Street. Conduct yearly follow-up testing of the residential wells and provide testing results to the property owner and township. Number 2 is include quarterly well testing for the 12 monitoring wells shown on the Ebert plan. Number 3 is as part of the well testing regimen. Oh, it says regime, but it should be regimen. Include testing for heavy metals as well as PFAS and its precursors as based upon the EPA's standardized monitoring framework as defined in the April 2024 EPA fact sheet titled EPA's Final PFAS National Primary Drinking Water Regulation, Monitoring and Reporting. Number 4, the perimeter of the currently proposed and any future proposed drip disposal fields shall be located at least 500 feet from any house. As has been pointed out, that was an initial determination by the zoning officer, which was later determined not to be part of the ordinance. But it is the recommendation that that restriction still be used for this drip irrigation system for some of the reasons that Attorney Blasey mentioned during his presentation. Number 5 is the drip disposal area under the special exception shall be limited to daily flow of 120,000 gallons per day in the R1 district. I know that's what has been proposed to this board. We would like to have as a written a restriction that is placed on any approval. Number 6, only domestic sewage shall be discharged into the drip disposal field in the R1 zoning district. No sewage shall be discharged into the drip disposal field that is defined, classified as industrial waste by PADEP. And number 7, applicant shall comply with all DEP permit conditions. A public hearing shall be conducted in conjunction with the planning module, and permit application, township shall be copied, a permit application, and township shall be copied on all correspondence with DEP. So again, our position is that the application should be denied, but those are the conditions that if this board approves that we would request. And that's all I have.
Can I ask just one question to clarify, Mark, maybe you can clarify? When they do this, is there a public hearing for the DEP to approve the planning model? Is that occur?
There can be a public hearing. Once it's complete, once the application's complete, which means that the county planning commission and other people sign off the township planning commission, it goes back to the supervisors. We have to publish a notice. There's got to be a notice, and there's got to be 30 days before the board can act. Somewhere in that DEP process, people can ask for a public hearing, and there have been a number of public hearings, particularly with regard to NPDES permits, but the same procedure applies, and I have seen it. So yes, there can be a public
That's your
hearing.
understanding? too?
Yeah, I believe that is true, but I mean, our position on requiring it is that requires a request for it to be done, so as opposed
Yeah, understood. I guess the reason I ask is I don't, if the board's inclined to grant this, I don't want it to be a condition that the board doesn't have any authority to.
Well, they have
No,
to.
no, 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 no. no.
They have to act, so they can do that in a public meeting, and they can hold whatever they want to hold.
Right, understood. What I'm saying is that I didn't want to create a new legal
Yeah.
process that doesn't exist.
No,
Okay,
Council's
you understand what I'm saying?
yes, it is.
Okay. Yeah,
Might I just add, I guess, one thing, I did not read our recommendations into the record. I assumed the board was gonna have the
yeah, we'll have
opportunity,
your stuff in there.
would look at it before they make a
Yeah.
decision. And lastly, also in there, we have requested that an EIS be prepared, an environmental impact statement, which the zoning ordinance requires, or at least consideration of those conditions be conducted before it makes a decision. So that's referenced in there as well. I didn't cover everything in my oral statement that's in the text,
Yeah.
is what I'm saying.
Yeah, I mean, for example, I didn't include any of the motions that were filed back and forth via email as part of the record. I mean, that may, you know. All right, let's clean up the exhibit situation and then
Do I get rebuttal?
need it.
Well,
The only reason I'm asking, we have an hour and 20 minutes.
well, in my view, there were misstatements made. I will try and keep it limited. The first thing that I'd like to point out to you, and if you look at Mr. Blasey's materials, there's not one single case cited in his materials. Mr. Blasey has taken the freedom to tell you that you can take into consideration whatever you want. Chad will tell you, and I think Adrian agreed, that I set out what the law is. But Mr. Blasey does not give you any criteria. he's asking you to go outside of your authority. He's just ignored the law. And in that regard, he's admitted that what he's telling you to base a denial on is speculation. He said it. I couldn't have described it any better. It's speculation that the price may go down, that this will go wrong, or that will go wrong. That's not permitted. That's not evidence. Now, I want to address what Adrian addressed about, and Doug addressed about, we have a determination by the zoning officer. Let me first of all say, Adrian, your statement that the board has the right in this proceeding to revisit the zoning determination is absolutely incorrect. The Commonwealth Court, in a case called Bachman, I don't have it here because I didn't expect to hear that, has said clearly that the only time that a zoning officer's decision can be adjudicated is when there is an appeal. So this board, as Doug said, does not have jurisdiction to reconsider the zoning decision. The zoning officer made two determinations. We saw the first determination, and we believe that she made a mistake with the 500 feet. We took an appeal. The township did not intervene, do anything. The township, nobody has taken appeal from that decision. I believe that the issue of whether or not this type of use can be a special exception has been waived and has absolutely been determined. The last thing I want to address is Adrian's comments about this being a system that's only provided for this one user. First of all, that's absolutely incorrect. But he presented no evidence to that. There is a signed agreement between the municipal authority and my client, and there was a prior version of that agreement to take care of the same thing that's been, I believe, on the township's website for how long? A year and a half, 2 years? And that plan, that agreement says that the plant will be capable of 400,000 gallons a day of treatment. It reserves unto the township 100,000 gallons of that treatment capacity without a charge. The agreement, the original agreement said that the township was going to get 30,000 gallons of disposal capacity because the township, before we even got involved, had Joe Valentine test the soils on an 18-acre part of the park. And he determined that that 18 acres could absorb like 30,000 gallons a day of treated effluent. The first drafts of the agreement included that and said that because the township was going to include the park, that there would be that 30,000 gallons allocated to the township, which was intended to take care of all of the problems along 611. The township, after people protested about using the park, took that out of it. But this is a system that's going to that guarantees to the township 100,000 gallons a day of treatment capacity to take care of the long-standing problems that it has. So the statements that were made Mr. Cousins made these statements without any reference to the record. And in the township's records, he could have brought forth whatever he wanted to prove that this is not a public system. He elected not to, and then he really was wrong. So those are my comments.
I need to rebut.
Go ahead.
So, the applicant just introduced a whole bunch of things that are not in front of this and have not been put into evidence.
Did we make the current
No,
contract part of the?
No,
absolutely not. And the evidence that was presented by the applicant showed a benefit only for the applicant. There was no evidence that it showed any benefit for anybody other than the applicant and the property and his tenants. So that's the evidence that was presented by the applicant.
the planning module is part of the evidence. The planning module says it will be a 400,000 gallon plant and that it will be 100,000 gallons will be reserved to the township. I mean, it's there. Adrian keeps saying things that are there are not there.
All right. Anything else?
No, that's fine.
I would just like to say that I think I heard Mr. Kaplan say the real estate valuation was totally speculative. That was not, I never said that. That wasn't the testimony of Mr. Sterling. I think Ms. Duffield at one point said she had done some, her own checking. It was that Mr. Joyce
All right.
so people talked about it. It's a real factor now. It's what the market is saying about it. And I guess would only say if it's not an allowed use, the fact that, and this is now an appeal before the board's got to make a decision. You don't ratify something that's illegal. It's as simple as that. If you conclude it's a lawful use, then you may do that. But we're asserting that the township code does not contemplate this activity in that area. It's not an essential service, and that's it, and you shouldn't approve.
So let me give one more sentence. I have the essential services definition
You got it.
that Adrian read. And at the very end, in addition to everything else, it says, but not including buildings, except telephone booths, firehouses, pump stations, treatment plants, and similar facilities which will also be considered as essential services. If I understand Adrian's argument,
It does.
pardon me, either one of them, a treatment plant is clearly allowed as a essential service, but the disposal of the treated effluent is not.
Right.
Well, that's not and because it says, and similar facilities. So, and the zoning officer made her decision, and there's no appeal.
Okay.
All right,
Let's get to this exhibit situation. Doug, I'm a little confused, at least. I don't think it'll be on the record until let's figure this out, and then you want to take a break and maybe discuss it amongst us, and then we can come back.
well, my partner sent a detailed list. He went back after Doug's letter, and he went through every exhibit, and he annotated it.
Yeah.
Are you in agreement with that?
I'd have to look at it in large part. The naming is different, and he didn't include them all, and there was, I had some earlier confusion. You want to talk about it off the record for a minute?
We're going to take a break and use the restroom. Okay, we're gonna go back on the record here, just to clear up a few housekeeping issues. So the exhibits marked I-1 through 28 will be admitted. I-29 is not admitted as part of the record. And then I-30 through 32 are admitted. Okay. Any other housekeeping matters before? Okay.
Oh, actually,
Yeah.
did we had a discussion at the last one about that one exhibit that I marked. That
Was it T2? Yeah.
T3, I believe?
Yes.
Yeah, you asked.
What's the planning commission notice?
Right, and I think we were just going back on what it was. I don't think it actually got admitted.
All right, so T3 then would also be admitted. I assume T1 through T1 and 2 were admitted.
I believe so, yeah.
Okay, all right. So T1 through T3 are admitted as well. Okay, anything else?
Not for me.
Okay. Motion to use executive session?
So moved.
All second. Okay, zoning board's back out of executive session. Are there any motions from the board?
So move.
What's the motion?
Back in session.
Yeah, we're back in session.
Back in session, yeah.
Okay. Okay, back in session. Are there any motions from the board with respect to this application?
Yes.
Okay.
Is my mic on? How about now? There. Sorry about that. Okay, I'd like to move, based on discussions that we've just completed, a motion that we would approve the application, but with conditions. Before I go into each condition, I would tell you that we're largely taken upon the advice of the township attorney, and who was referred to us by the board. Just to run through the conditions, that once this facility was built, it would be turned over to the township or the municipal authority. That's not on the township engineer's recommendation, but I think it's an important point. After that, I'll run through the township engineer's recommendations, which I believe I'm putting into form of a motion. The first one is to provide baseline well testing for residential users within 1,000 feet of the proposed drip disposal fields on both sides of Potomac Street. Conduct yearly follow-up testing of the residential wells and provide testing results to the property owner and the township. The second, or actually in this case the third, but it was the second of the townships, to include quarterly well testing from the 12 monitoring wells shown on what's known as the Ebert plan. Another condition is, as part of that well testing regime, include testing for heavy metals as well as PFAS and its precursors as based upon the EPA's standardized monitoring framework. As defined in the April 2024 EPA fact sheet titled EPA's Final PFAS National Primary Drinking Water Regulation, Monitoring and Reporting. Additional condition, the perimeter of the currently proposed and any future proposed drip disposal field, or plural, shall be located at least 500 feet from any house. Additional condition, the drip disposal area under the special exception shall be limited to a daily flow of 120,000 gallons per day in the R1 district. Russ, let me see your note for the first one. I missed a word here. No industrial sewage shall be discharged into the drip disposal field in the R1 zoning district. No sewage shall be discharged into the drip disposal field that is defined or classified as the industrial waste by the Pennsylvania Department of Environmental Protection. And then the final would be the applicant shall comply with all DEP permit conditions. The last one? The applicant shall comply with all DEP permit conditions.
And I think we would have included requests that a public hearing.
Oh, yeah, let's go. We're going to adopt I will amend the last part. The sentence stands, a public hearing shall be conducted in conjunction with the planning module and permit application township, let me just say that again. Applicant shall comply with all DEP permit conditions. A public hearing shall be conducted in conjunction with the planning module and permit application. The township shall be copied on all correspondence with the DEP. And then the last point is, as stated, at least 100,000 gallons of capacity would be reserved for the township. That would be net. Tony, did I state that correctly?
Net capacity, yes.
Mr. Chairman, that's the motion as I understand, that I'm making at this point.
Is there a second?
I'm sorry.
Is there a second to this motion?
The conditions?
I'll do second to approve the conditions.
All right,
Okay, any
all the,
discussion?
well, amongst the board.
Yeah, is there any discussion? Are there any questions for anybody here?
No? Okay. Just do a roll call, those in favor?
All those in favor?
Aye.
Aye.
No.
No.
Okay. Aye. 4-1.
Hold the board.
Yes.
You said,
No.
you said no.
Okay, so 3-2.
Okay.
Okay. Okay. Everybody, written decision within 45 days, and then you can appeal thereafter, I assume that's what's gonna happen.
Who was the two and who was the three?
I think Mr. Rego and
Um,
Mr. and
I
and
was
staff
two.
were no, and then the other three were yes. Okay? Okay,
Motion
that's all we have?
Yeah, is there a motion to adjourn? Second?
You can make a motion.
All in favor?
Yeah, Tony.
Aye.